Hey guys, today I'm going to talk about lasting power of attorney, which I shall call LPAs. Now, what is a LPA? An LPA is a legal instrument that allows you to appoint people that you trust to act on your behalf if you lose your mental capacity, your mental functioning to act on your behalf on personal and financial affairs. Now, you must be above 21 and have mental capacity. That means you must be mentally okay in order to make your LPA. I have people coming into my office, in a wheelchair, and they are like almost comatose. And when I ask them questions, they are unable to answer. That means they have lost their mental capacity. And when you have lost your mental capacity, you cannot do an LPA. You need, your family members have to do this court application called appointment of deputy, to appoint someone to look after your personal and financial affairs. Now, what is mental capacity? According to the Mental Capacity Act, a person lacks mental capacity if he is unable to make a decision for himself in relation to a matter because of an impairment of or a disturbance of the functioning of the mind or the brain. A person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, or to retain that information. That means to absorb and to remember the information, to use or weigh the information as part of the process of decision making, or to communicate his decision, whether by talking, using sign language, or by any other means. Common examples of loss of mental capacity would include Alzheimer's disease, dementia, stroke, not just ordinary stroke, but a stroke causing a person to be unable to make decisions and to communicate, or coma. Now, why do you need an LPA? Because when you lose your mental capacity, your ability to make decisions for yourself, you are still alive. So a will does not kick in, okay, because you are still alive. But because you cannot make decisions for yourself, CPF will not allow you to withdraw your money to pay for your medical expenses. The banks will not allow your family members to withdraw your money because the bank account is under your name. So you have to withdraw the money. Your family members have no right to withdraw the monies in your bank account to pay for your medical expenses. Your family members will not be able to sign insurance claim forms in the event that your mental capacity arises from a work injury incident. If you want to make a claim, for example, under the Work Injury Compensation Act, you have to sign the forms. But if you lack mental capacity, you can't just sign the forms. You need an LPA to appoint another person to sign on your behalf. Also, an LPA will allow your family members, people you trust who are called donees, okay, to rent out your HDB flat or condo, to sell your HDB flat and condo to pay for your medical expenses, for your nursing home, blah blah. There was an article in Today newspaper over here. A young woman of 23 years old was involved in a car accident and was reduced to a vegetative state. So without an LPA, the banks will not allow the family members to withdraw money from her account to pay for her medical bills. Why won't the banks allow her family members to withdraw her money to pay for her medical bills? Very simple, because the banks do not have her consent. She was in a vegetative state, so her assets were frozen. So her father had to go through the time-consuming and challenging process of applying to the court. You have to get a court order called deputy, appointment of deputy, to manage her affairs and to access her bank accounts, her CPF, to pay for her medical bills. Another example would be a man who suffered from a stroke. He is not able to communicate with his family by talking, by using sign language, or through any other means. He has 2 children, both under the age of 21. The wife sought compensation on his behalf under the Work Injury Compensation Act, as well as other forms of insurance compensation. The insurance monies would mainly be set aside for his medical treatment, future medical needs, and the children's educational expenses. Unfortunately, without an LPA in place, the wife had to go through the appointment of deputy process, which is quite a lengthy process. You can go to court up to 10 times. The lawyer has to go to court up to 10 times, and the waiting time is like more than 6 months. So if the man had done an LPA, everything would be much simpler. The wife can just use the signed LPA, the registered LPA with the Office of the Public Guardian. Go to the bank, show it to them, withdraw the monies. Go to CPF, show to CPF, withdraw the monies. Go show to the insurers, sign the claim forms and get the money. Everything is so much quicker. So what happens if you don't have an LPA in place? As I've mentioned before, earlier in the video, one of your family members has to take out a court order called appointment of deputy. Okay, this is a very expensive application. Most law firms charge about $10,000. Why is it so expensive? Because it's a very tedious and long process. The lawyer has to populate the court forms with a lot of information. A lot of information has to be provided by the family, as well as particulars of the person who has lost mental capacity. You will need doctors' certificates. You will need all kinds of affidavits and all that. And if the lawyer is lucky, he can get the order after one court hearing. One of my colleagues had to go to court 10 times for an appointment of deputy because the judge kept asking him to amend the order to his satisfaction. So that's why it's a very troublesome and long drawn process. That's why most law firms charge about $10,000 for an appointment of deputy. So in order to prevent all this thing from happening, easiest and cheapest way is to just do an LPA.